On 6th of January 2024, Uttarakhand's Chief Minister Pushkar Singh Dhami made headlines by introducing the much-debated Uniform Civil Code, or UCC, in the State Assembly. The UCC proposes to standardize laws regarding marriage, divorce, succession, and live-in relationships across all communities in the state. The new bill aims to replace various existing laws applicable to respective communities which are inconsistent with each other. However, the legislation excludes the scheduled tribes that comprise 2.9% of the state's population. The Uniform Civil Code proposes changes to succession laws, aiming to standardize them across religions. Currently, Muslims can allocate 1/3 of their property via a will, with the rest following Quranic norms to avoid complete disinheritance. The proposed UCC eliminates restrictions on the portion of property that can be passed on through a will. It also prohibits polygamy and sets a minimum marriage age of 18 for women and 21 for men. For Hindus, the Uniform Civil Code changes the succession laws. It removes the Hindu law's distinction between ancestral and self-acquired property. It also overlooks the coparcenary rights under the Hindu Succession Act 1956. Under Hindu law, being born in a Hindu undivided family, or HUF, grants one the automatic legal rights to ancestral property, making him or her coparcener from birth. This means that a Hindu individual does not have the authority to independently sell a joint family property if his descendants are alive. However, in the context of self-acquired property, an individual has the freedom to dispose it off as he sees fit. Senior advocate Mahip Singh explains what happens to coparcenary rights under the UCC.
Under the Hindu Succession Act, it held that a property can only be held either as a coparcener or as a self-acquired property, right? The bill or the Uniform Civil Code, which the objective of this law is to create equality among gender, to create equality among brothers and sisters, and to create equality even with respect to coparcener and a self-acquired property. It is aiming to do away with the coparcenary system, and it is trying to extend the same scheme of succession to all people, irrespective of religion. So therefore, all property will pass on as an individual property as per the scheme of intestate succession, which has been laid down by the code. And the benefits of being a coparcener to that extent have been attempted to be done away with.
Further, the UCC bill does not specifically consider Hindu undivided families as a distinct category. HUFs currently hold legal recognition as a trading entity, treated separately for taxation purposes under the Income Tax Act 1961, with certain exemptions. A 2018 report by the Law Commission has indicated that HUF system could potentially be exploited for tax avoidance. Senior advocate Sanjay Hegde elaborates on the tax implications after UCC.
The Uttarakhand bill does not touch the HUF system. The HUF is a matter of central legislation, the Income Tax Act, which provides for HUFs, and for a separate taxing entry for HUFs apart from the individual. Uttarakhand's bill doesn't touch it, so there is no impact whatsoever. Even people within Uttarakhand can continue with their HUFs.
Current succession laws in India are governed by the Indian Succession Act 1925, the Hindu Succession Act 1956, and non-codified Muslim personal law. Uttarakhand's proposed UCC has prompted other BJP states like Rajasthan and Gujarat to consider introducing similar laws in the future. But can state laws override central laws?
No state law can supersede a central law. However, the basis of this no is that the Article 246 of the Constitution of India, it delineates the distribution of legislative powers between the central government and the state government. Now, Hindu Succession Act 1956, or the acts which you just named, they form part, or the laws of inheritance and succession which are stipulated in those acts, they are a central law which has been devised by the Parliament of India. Now, when such a law is there in place, Article 254 comes into picture, which says that inconsistency between laws made by the parliament and laws made by the legislature, the laws made by the parliament would prevail.
The proposed UCC law also mandates the registration of live-in relationships in Uttarakhand. Failure to register within a month may result in a maximum penalty of 3-month imprisonment. The law also requires live-in partners under 21 to notify their parents upon registration. While some legal experts suggest the registration may protect live-in partners from harassment, others argue that it would only invite more trouble for couples.
This law also has extraterritorial jurisdiction. If you happen to be a resident of Uttarakhand, but living away from Uttarakhand, even if you enter into a live-in relationship, you still have to register it, and you go to the nearby registrar and hope that he then transmits it to the registrar in Uttarakhand. So a girl from Dehradun who has taken up a job in Bangalore and then decides that she wants to be in a live-in relationship, or she wants to share accommodation, she would, after a month, have to compulsorily register. So that's why I said all these things are not practical. So the mere fact of registration is no form of protection. And it also doesn't protect you from any harassment. No landlord is obliged to give flats on rent to people who are registered as live-in partners. All that will happen is that you will actually invite further harassment.
Legal experts believe that the UCC law is a positive step toward harmonizing inconsistent existing laws. However, its acceptance by the citizens it affects remains uncertain.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.
She's working her way to the corner office. Business Standard.